1989 and the Supreme Court order, then the subsequent amendments which were made. It was a bit controversial, so that is why I would like to take up. So, the topic is the Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act, Atrocities Act 1989, then the subsequent Supreme Court verdict and the amendment and its amendment. Okay. So, this Act 1989 was passed to prevent the atrocities against scheduled castes and scheduled tribes, and this also sometimes it is just called the Atrocities Act. It is not SCST, Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. People generally call it Atrocities Act, and it was passed in 1989, as I already mentioned. And a number of, and it is section 23(1) of the Act authorizes the central government to frame rules for carrying out for the purpose of the Act. Section 23(1) of the Act authorizes the central government to frame rules, for carrying out of the purpose of the Act. So, they can frame rules, but the problem was, over a period of time, a number of cases of misuse of this Act. See, now one of the important provisions of this Act is, if a person is accused of practicing untouchability, he can be arrested and it's a non-bailable offence. See, now one of the important provisions of this Act is, if a person is accused of practicing untouchability, he can be arrested and it's a non-bailable offence. Okay. A person, if he is accused of practicing untouchability, according to this Act, it is a non-bailable offence. And not only that, there is no anticipatory bail also. No anticipatory bail. Anticipatory bail in this case. So, now from a what happens sometime is, a person, if suppose a scheduled caste or a scheduled tribe person, if he alleges that X or Y or Z practice untouchability, the police can immediately arrest that person. No anticipatory bail, nothing, and no bail, non-bailable offence, and he will be in jail for many months until unless it is proved in the court that he has not practiced that. He has not done. So, there is always a chance of misuse, because there is an arbitrary power. The police also can do it. See, it is not that a scheduled caste person or a scheduled tribe person should go and complain. If some issue happens, the police only will suggest that fellow, you file a case, I will show, I will teach him a lesson. If there is some some vengeance to be taken out, if there is some some score to be settled, it is a beautiful law, because all you require is a complaint and then you are automatically in jail. So, a number of cases of misuse of this Act has been reported from many parts of the country, and Supreme Court in March 2018 declared that there has to be some some corrective steps. In March 2018, Supreme Court gave a verdict, and Supreme Court said that Supreme Court banned the immediate arrest of a person. Supreme Court banned the immediate arrest of a person. Banned the immediate arrest of a person accusing of violating the Untouchability Act or the the Atrocities Act. So that basically the idea is to prevent an innocent person from arbitrary arrest. So, immediate arrest should not be there, to prevent an innocent person from an arbitrary arrest. An innocent person from an arbitrary arrest. So, if an innocent is arrested, so naturally it is a violation, everything. So, but naturally when this law was, when the Supreme Court said that there can be even anticipatory bail in such a scenario, Supreme Court said that the Atrocities Act of 1989 is very harsh. There is a chance of misuse in this, and genuinely, see actually, and now let me just remind you what is the truth on ground. See, the truth on ground, two, three, realities we cannot forget. Number one, the scheduled castes and scheduled tribes, especially in villages, they are still, still the practice of untouchability and discrimination is still going on. They are discriminated. Discrimination is still going on, that is the reality. Quite unfortunate, but that is the reality. Those who are actually facing discrimination, they may not be even aware of their rights. They don't even know that there is an Atrocities Act. They don't even know that there are fundamental rights. They don't even know that there is Article 17. So, this misuse is going on endlessly in our country, no doubt, and the vast majority, maybe more than 90%, are still suffering silently. But there are a small, I will say, another reality is a small, minuscule minority of scheduled castes and scheduled tribes who are comparatively educated. So, few of them, and who have the guts and who are capable also. So, those who are educated and they are aware of the law, and some of them, they know this is a draconian law, because you have to just accuse somebody, the rest is gone. That fellow will go to the jail. See, even if it is other petty issues, it may be a personal animosity. Even if it is other petty issues, it may be a personal animosity, it may be a business deal, it may be something else. Now, even at that stage, if you go and complain to the police that so and so has practiced untouchability, the other side can easily go to the jail. So, there is and there can be a nexus between police and some influential. See, suppose a scheduled caste leader, a local leader, some education, some awareness, and a nexus with the local police, it can be a deadly combination. So, what is happening is, there are instances of misuse of this law. There is no doubt. You talk to any officer, they talk about this, especially an IPS level officer. Many of my students, who they always say, sir, in every district, in every police station, this issue comes. Normally, before filing an FIR, even a complaint comes, then normally a senior officer will inquire, because the local SHO may be under the influence of something or other reason. But an IPS level officer or a senior officer will look into this case, and if he is convinced that yes, there is a truth in the matter, then only normally it is an informal arrangement, because openly you cannot do that. If a complaint comes, you have to file the FIR. But many a time there is an informal way of handling the situation to avoid any misuse of this. So, misuse is a reality, no doubt regarding that. So, this may be because of the nexus with the police, maybe because some of these comparatively educated, some of the influential, some of the politically motivated, such people are able to misuse. That is what Supreme Court has said that we should avoid. So, innocence should not be, see, 99% of the cases may be correct, but there is always a possibility of 1 or 2%, maybe 5% of the cases are fake. So, that is what Supreme Court has said. So, but when Supreme Court said that this is not done, there should be there should be a provision for anticipatory bail, or automatic arrest should not be there. So, this has taken a political color. Some of the scheduled caste and scheduled tribe organizations, they took it as a as a dilution of their rights. protest started across India. And the government, the Prime Minister Modi government was accused of not doing enough to protect the rights of the Dalits. And elections were also approaching. Opposition naturally joined with the, the scheduled caste, scheduled tribe organizations. So the government felt that this can affect their vote bank. So immediately in Parliament, an amendment to the Atrocities Act came in 2018, in August 2018. The Scheduled Caste, Scheduled Tribe Atrocities Act amendment bill came, SCST Atrocities Act amendment, and it was passed. Obviously, every political party participated, and an amendment act, Scheduled Caste, Scheduled Tribe Atrocities Amendment Act was passed. Prevention of Atrocities Act was passed in August 2018, and the bill inserted two sections, section 18A 1A, section 18A 1A. It says the investigating officer shall not require approval for the arrest. I mean, earlier what is happened, the investigation officer was normally asked to, the senior officers will give approval, then only arrest should be there. So there is a chance of delay. So now is the investigating officer shall not require approval for the arrest. Shall not require approval for arrest. So no need for approval for arrest against whom an atrocity is accused. And also but the problem is this act violates the basic principles of liberty and accountability. So with this amendment, what has happened, investigating officer can arrest anybody. See, we should punish if somebody violates the law, but it should be, and who should punish? The court should punish. See, now you are only accused of a crime. See, the problem is, suppose A is accused of, or there is an allegation, is alleged that A has done some crime. Now, or there is an allegation, is alleged that A has done some crime. Now, only because there is an allegation, he need not go to the jail. But if he has actually done, the court, who will decide whether he has done the crime? The court should decide. If the court finds that yes, I have done the crime, I should go to jail. But only because I was alleged that I have done the crime, I should not go to the jail. But now what is happening? So this has actually, what is the end result? What is the result of it? What is the result? The result is, it violates the basic principles of liberty and accountability. Violates the basic principles of liberty and accountability. It violates the basic principles of liberty and accountability after this amendment. And Supreme Court, in fact, this we are living in in fact, Supreme Court earlier said we are living in a civilized society. There are many growing instances of misuse. If there is a misuse, we should plug the misuse. We are not saying Atrocities Act is bad, but misuse should be avoided. That is what even Supreme Court said. Supreme Court said we are living in a civilized society, we should avoid this misuse. But now this new law can be used, especially by the police. See, the police many times they are not very innocent. They know how to manipulate. See, now when they get an opportunity to harass a person, the police can always use this act. So this can, according to many, it is felt that the police can easily misuse. The police with a local, what do you call, agreement with a local leader, especially many times a politician, police nexus will come. The police can easily misuse this act, this amended act, because they can be only on the basis of a mere allegation. You can misuse and you can destroy a person's life, his reputation, everything, sent to jail for many months in the process till it is proved in the court that he is innocent. By the time it will be too late. So then again, this amendment, the act also, this amendment also amended section 438 of the CRPC. Section 438 of Criminal Procedure Code, CRPC, and it is it says the amendment ruled out any provision for anticipatory bail for a person. So it ruled out any possibility of anticipatory bail. It ruled out any possibility of anticipatory bail in case of a person is accused of violating or practicing atrocities act. So the amendment amended, or rather the section 438 of the CRPC act, and which is whereby the possibility of atrocity, the anticipatory bail has been completely eliminated in this case, and that is how this amendment act was passed. Now it was challenged in the Supreme Court again, and finally in February 2020. Now you see, in February 2020, this matter came to the Supreme Court again, and Supreme Court accepted this amendment. So Supreme Court said that, see, earlier Supreme Court was accused of, in March 2018, Supreme Court was accused of diluting the Atrocities Act. Now the government made it stringent by amending it in 2018 itself. And in February, see, in September, see, that's what we said, there was a March 2018 judgment, then in September 2000, in August 2018, sorry, in August 2018, one second, in August 2018, amendment was made. So in February 2020, so March, then August, sorry, one second, in August 2018 amendment. So this is Supreme Court judgment, then amendment to Atrocities Act. So in February 2020, this matter came once again in front of the Supreme Court, and Supreme Court upheld the amended act of 2018, upheld the amended act. So that the act then amendment to Atrocities Act. So in February 2020, this matter came once again in front of the Supreme Court, and Supreme Court upheld the amended act of 2018, upheld the amended act. So that the act is fine, so non-bailable and no anticipatory bail, and so it nullified the controversial, the earlier March 2018 verdict, and Supreme Court itself, and in fact it has said that it is wrong on the part of Supreme Court to treat all cases as as a liar or a crook. So Supreme Court now says it is wrong on the part of Supreme Court to suspect the cases as false. See, in the March judgment, Supreme Court said that many of these cases are false. Innocents are suffering. Innocents are accused of practicing and actually it is happening. That's the beauty. Now the Supreme Court has changed everything. See, now the problem in our country is we slowly, one by one, this judgment, the way it is coming, it is very sad that Supreme Court has stopped applying its mind. If when I say this, it's very sad. We feel bad about the whole thing. Supreme Court should be there to protect the rights of everyone. Supreme Court should protect the rights of the scheduled caste, scheduled tribe, OBC, every citizen of this country. If the other side is the victim, we should find a solution to the problem. We are not finding a solution, and simply now the Supreme Court is singing the tune of what the Parliament has passed, what the executive has said. Supreme Court has stopped applying its mind, quite unfortunately. I am for stringent law. I personally feel anyone who, it's an inhuman act, anyone who practice untouchability should be sent to jail. But only those who practice untouchability should go to jail, not those who are being accused of practicing untouchability. If somebody is accused, that does not mean he has practiced. Court should decide. You should go to jail, only you give more punishment if it is found to be true that somebody practiced untouchability. But let it be proved by the court first, not only because somebody accused you of practicing untouchability. You should not go to jail. You should not be immediately arrested and sent to jail. Yes, the case should be filed, inquiry should be conducted. Then it has to be decided by a court of law, and the court should say, yes, he has practiced untouchability, he should go to jail. But that is totally gone. Now now the Supreme Court is saying that the atrocities are still going on. We see, yes, atrocities are going on. So, but again, not all cases are genuine. What Supreme Court said on March 20th is the correct thing. Absolutely no doubt. That is the truth. There are occasions of misuse of this act. See, the cardinal principle of criminal justice system anywhere in the world, especially in a democracy, is even if 100 criminals escape, one innocent should not be punished. There should be a foolproof mechanism. If innocents are punished because of the loopholes in the law, we should try to rectify that. That is what Supreme Court said. And give anticipatory bail, give them bail, arrest them only after proper investigation and everything is done. Then let us punish them in the court. What is wrong with that? But that doesn't suit the political requirements. The vote bank politics. Everybody is a party to this kind of a crime. Quite unfortunately, the Dalits are not getting justice in any case. Now you are playing, this is a political game now. So this is quite unfortunate that Supreme Court has fully accepted. Supreme Court has said that, saying that the government is enacting this act, saying that scheduled caste and scheduled tribe continue to face this. Yes, they are continuing to face the same social stigma, poverty, humiliation is still going on. But making a law non-bailable is not solving the problem. It's a social crime. Society should involve. unfortunate that Supreme Court has fully accepted. Supreme Court has said that, saying that the government is enacting this act saying that scheduled caste and scheduled tribe continue to face this. Yes, they are continuing to face the same social stigma, poverty, humiliation is still going on. But making a law non-bailable is not solving the problem. It's a social crime. Society should be involved, and society should be educated, and we have to have a massive campaign. We have to educate people, we have to make the people aware of their rights. But to make them aware, they need education, they need gainful employment, they should be taken out of poverty. So without doing all these things, this is not going to happen. So the 2018 amendment has nullified the March 2018 judgment of the Supreme Court, and which allowed anticipatory bail, and which even said that proper inquiry should be there. So all these things had been eliminated. So the original 1989 Act did not have anticipatory bail. Now also there is no anticipatory bail. So in the 2018 judgment, 2018 March judgment, Supreme Court said that there should be anticipatory bail. Now that has been taken away, and that is how it is said. So the SC/ST Act 1989, now the argument is the Scheduled Caste Scheduled Tribe Act 1989 is the least which the country owes to this section of the society who has been denied several civil rights since generations and have been subject to humiliations and harassment. That is the government's argument. But the point what I am still making is, in the name of this act, innocence should not be punished. False cases should not be filed, and innocents should not be sent to jail unnecessarily. There should be justice on both sides. And in many a times, those who are actually suffering from untouchability and discrimination, they are not going to any police station, or they are not complaining at all. Only a very few who are educated, who are aware, they are going to the police station and complaining, and in many cases it is false case. It's like dowry case. Many women are suffering from dowry and the dowry harassment. But who are those who go to the police station? They are the influential one, the better off one, the middle class, upper middle class. They go to the police station and complain. They create a nuisance there. So many a times, even this dowry law is also non-bailable, and because of the non-bailability, many innocents are going to jail. So again, dowry is a social crime, untouchability is a social crime. Social crimes cannot be dealt with by law alone. Law is important, but you cannot make draconian laws and make it non-bailable, and then harass innocents also. We should not do this. This law is in the hands of the police now. Police can play a game, and in the process, many a time innocents are suffering. So we need to punish. There should be stringent punishment to practice untouchability. No excuse whatsoever, but only those who practice this, those who have done the crime should be punished, not those who have been accused of doing it. So March 2018 Supreme Court judgment was the right one. Amendment has been made. Now once again it has made very stringent with no anticipatory bail, and anybody can be arrested, and Supreme Court also vetted and said that yes, this is a good law now. So Supreme Court has completely overturned what they said earlier. The right thing what they said earlier has been changed, and now accepted what the government is saying or what the parliament is saying. That is where I am saying that court has stopped applying its mind, and the court has stopped standing on behalf that court has stopped applying its mind, and the court has stopped standing on behalf of any person whose justice is violated. Court should stand for anyone. All are Indians, and every Indian has a right to get justice, including those upper caste who are being accused of practicing some untouchability. If they have not done, they should also get justice. Dalits should get justice. So, you cannot be, justice cannot be blindfolded and, only some get justice and others don't get it. Everyone should get justice. And unfortunately, that is not the case, at least in this law, which is quite sad and unfortunate. So, that is about the amendment to the Atrocities Act of 1989, which has happened in 2018.